Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. Today is our 25th lecture series. It is quarter to century. So this happens only because of your unity, your collaboration, your cooperation. And at the outset, yesterday Advocate on Record results have come. And some of our students have cleared successfully. So I wish and pray that our academy will produce more number of Advocate on Records in the future. So with this positive note, we always recite the preamble as our daily prayer. So I request each one of you to recite preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. Today we have gathered to discuss about a very important topic with respect to special leave petition. Majority of the cases are filed before the Honorable Supreme Court by invoking Article 136. We are having series of lectures on special leave petition because of the importance of the topic. So what is the topic for today? Can we raise a new plea for the first time in the Honorable Supreme Court? That is the question we need to answer. So can we raise new pleas before the Honorable Supreme Court for the first time? To answer this question, I want you all to travel along with me. Therefore, we can find out answers one after the other to find answer to the questions that we posed. So first and foremost, to answer this question, we are asking a question: can we raise new pleas in the SLP? SLP is dealt under Article 136 of the Constitution of India. So first and foremost, it is our duty to understand what is Article 136 and how Article 136 was interpreted by the Honorable Supreme Court of India. First, when we understand this, then everything falls in place. So let me tell you what is Article 136. It says, notwithstanding anything in this chapter 4 deals with judiciary, union judiciary. So notwithstanding anything contained in this chapter 4, the Supreme Court may, in its discretion, it is a discretionary power, and it can exercise or it cannot exercise also. That is why the Supreme Court may, in its discretion, grant leave to appeal against any judgment, any degree, any determination, any sentence or order passed in any court, passed by any court or passed by any tribunal in any matter within the territory of India. So such a wide powers, when we see word behind those words. The powers vested with the Honorable Supreme Court are very wide. And it is not a matter of right, dear friends. It is a matter of discretion vested with the Honorable Supreme Court, either to invoke its discretionary power or not. Whether the cases which we file before the Honorable Supreme Court, is it a fit case where the Honorable Supreme Court can interfere? So it is solely, fully based on the discretionary power of the Honorable Supreme Court. That is clause 1 says. What about 136 clause 2 says? That is an exception to clause 1. Because in clause 2, they say it specially petition will not be applied. From where? From any judgment, from any order, any determination, any sentence passed by a tribunal with reference to the armed forces. So therefore, any order pertaining to the armed forces, special leave petition is not maintainable. That is what clause 2 says. So having seen or having studied what is article 136 clause 1 and 2, let us understand in a better way with more clarity by referring to the interpretation of the Honorable Supreme Court in Code Distilleries. I am going to refer one case law where the Honorable Supreme Court has elaborately discussed about article 136. That is, the name of the case is Code Distilleries Limited. Code Distilleries Limited versus Shri Mahadeshwara so and so. It is reported in 2019 volume 4 Supreme Court cases, page number 376. 2019 volume 4 Supreme Court cases, page number 376, comprising of Honorable 3 Justices, Honorable Justice Dr. A.K. Sikri, Honorable Justice A.S. Abdul Nazir, and Honorable Justice M.R. Shah. In this case, I am going to refer to para number 9 because it was a matter referred by a referring bench. While referring the matter to the larger bench, what they have said about article 136. We may also point out in this connection that article 136 of the Constitution does not confer any right of appeal on any party. So therefore, it does not confer any right on any party, but it confers a discretionary power on the Supreme Court to interfere in suitable cases. Dear friends, what does it say? It is not a matter of right that is vested with the parties, but it is a matter of discretion vested with the Honorable Supreme Court. Clause 1 of Article 136 of the Constitution confers what sort of powers it is conferring. It confers very wide. The terms are very, very important, dear friends. It confers discretionary power to interfere in suitable cases. Clause 1 of Article 136 of the Constitution confers very wide and extensive powers on the Supreme Court. The article commences with a non-obstantive clause. The words are of overriding effect and clearly indicate the intention of the framers of the Constitution that it is a special jurisdiction. So that is why it is extraordinary appellate jurisdiction. It is a special jurisdiction and residuary power unfettered by any statute. It cannot be taken away by any statute or other provisions of chapter 4 of part 5 of the Constitution. The jurisdiction under Article 136 of the Constitution, of course, cannot be barred by statute since it is extraordinary power under Article 136. Article 136 is an extraordinary power which cannot be taken away by any legislation. So from reading this paragraph, the message what I wanted to convey to you is, it is a wide discretionary power vested with the Honorable Supreme Court. So what sort of wide discretionary power? In one of the judgments, the Honorable Supreme Court has held, when we are chasing injustice, our power is limitless, like the sky. So to do complete justice, to do substantial justice, there is no fetters on the discretionary power of the Honorable Supreme Court. Being a discretionary power, the Honorable Supreme Court do not want to exercise generally in all the matters. So they have restricted themselves. The Honorable Supreme Court restricted itself from exercising all matters by invoking their Article 136. Only under exceptional circumstances they exercise their powers. So now we have understood what is Article 136, what sort of wide discretionary power that they have. It is limitless when they are chasing injustice, when they are punishing the wrongdoer. So such a wide discretionary powers are vested. Now, coming to the question that I posed, can we raise new pleas for the first time in the Honorable Supreme Court? Let me ask one more question also. Why should we not take a new plea? In other words, why should we not take new plea before the Honorable Supreme Court? So the answer is, when the litigant, he files a case before the learned trial court, when he is aggrieved from the judgment of the learned trial court, he prefers an appeal to the High Court, and he says what was the wrong committed by the learned trial court. And thereafter, when he goes to the Supreme Court, he cannot put a new plea. So what was adjudicated in the trial court, what was adjudicated in the High Court, the same has to be before the Honorable Supreme Court also. That is the general rule. So the general rule or the general practice of the Honorable Supreme Court is that they will not entertain any fresh pleas asked for the first time before the Honorable Supreme Court, because the foundation of the case must be put up very strongly, very effectively before the learned trial court. Otherwise, if you take a new plea before the Honorable Supreme Court, you are literally converting the apex court as a trial court. You cannot make the apex court to adjudicate on the facts, and then facts can be proved only by documentary evidence or by oral evidence. So evidence cannot be led in the apex court. So therefore, any facts which is new, which you are urging before the Honorable Supreme Court for the first time, they will not allow it, because you put a case before the Honorable Trial Court as an apple. When it comes to the Supreme Court, you show that your case is wanting for orange. So that cannot be put up. Reason is, one more reason is, the Honorable Supreme Court is checking the correctness of the judgment delivered by the High Court. When you have not taken up such a new plea before the High Court, when you have not taken such a plea before the High Court, then you are depriving the learned trial court as well as the High Court from adjudicating upon such points. So that is also one of the reasons. And the third reason is, generally it is a settled principle of law. Whenever you seek for a relief, your relief must be based on your pleadings. Relief cannot be out of context. So when the pleadings are there, you have to argue based on your pleadings. At many times we have seen or we have witnessed before the Honorable Supreme Court, when we argue a particular point, the Honorable Judge will ask us a question: where have you taken? Show us the grounds. Where have you taken? Which ground that you have taken before the Honorable High Court? Show us. Even if you show the grounds, now the Honorable Supreme Court is putting up further questions. Where have you argued? You might have taken 10 grounds, but you must have argued only for 5 grounds. So where have you argued? Please show us. So therefore, dear friends, the settled principle of law is we cannot travel beyond the pleadings. So when we are pleading or when we are drafting a case, that must be very, very important. We must pay complete attention. That too, in the trial court, we must take up all the issues, all the pleadings at one go. Otherwise, it is an issue. Then we cannot file a subsequent suit also. It is barred by constructive res judicata. Section 11, clause 4 says, in the previous suit, you had ample opportunity to take up a plea. If you fail to take up, then you cannot take it up in the subsequent suit. So therefore, dear friends, when you are adjudicating on a particular case, everything must be put up in the learned trial court. When all the opportunities are given to the opposite side also, as well as to the learned trial court also, to adjudicate upon all the points based on the evidence, then correctness of the trial court can be checked or can be supervised by the Honorable High Court at appellate stage. Thereafter, correctness of the High Court judgment can be supervised, can be checked by the Honorable Supreme Court. So this is a general rule. Generally, on facts, the Honorable Supreme Court will not entertain a new plea, for which I would like to refer few cases, few circumstances under which the Honorable Supreme Court has denied. And what are the exceptions? There are certain exceptions also where they will allow the new plea. I will tell you the exceptions also. Now we are moving on to the general rule, where generally the Supreme Court will not accept the fresh pleas. The name of the case is Jagannath Behera. Jagannath Behera versus Raja Harihar Singh. Jagannath Behera versus Raja Harihar Singh. It is 1958 Supreme Court Report 1067. 1958 Supreme Court Report 1067. In this case, what has happened? The court held that the question whether any special law or customs prevailed in the merged territory was one of the fact and could not be allowed to be urged for the first time before the Supreme Court. So whether which law will be applicable in the merged territory, whether customs law, customary law or the special law. So the Honorable Supreme Court has held it is a question of fact and you cannot raise this for the first time. So what is the principle behind rejecting this plea? The principle that was laid down was that where the determination of the question raised required evidence in regard to the same, it would not be fair to allow that question to be agitated. So therefore, when we take a new plea, when it must be supported with certain evidence which cannot be done in the apex court, therefore the Honorable Supreme Court rejected from taking a new plea. The second is in Venkataramana Devaru versus State of Mysore. This is yet another case, dear friends. Venkataramana Devaru versus State of Mysore. This is reported in 1958 Supreme Court Report 895. In this case, what was the fresh plea or new plea that was taken before the Honorable Supreme Court was whether the temple was a private one or not within the purview of Madras Act 1949. I repeat, the issue before the Honorable Supreme Court was whether the temple was a private one or not, whether will it fall within the purview of Madras Act 1949. That was the question. But the Honorable Supreme Court did not allow the plea, did not entertain the fresh plea. For the simple reason they have said, the said point was not taken in the pleadings in the court. So therefore, you are traveling beyond the pleadings. You should not do that. Therefore, they have rejected. Now, since I have said about under what circumstances they reject, I will tell you an exceptional case where they will accept the fresh plea. Fortunately, I have dealt with this case personally. The name of the case is, it is not reported anywhere because it is I handled personally. The name of the case is Raja Bhaiya Singh versus State of Uttar Pradesh. Raja Bhaiya Singh versus State of Uttar Pradesh, UP. So what was the case? Raja Bhaiya Singh was convicted for the offense of murder and sentenced to life by the learned trial court. Now he is aggrieved, Raja Bhaiya is aggrieved. He prefers an appeal before the Honorable High Court of Allahabad. There also the Honorable High Court confirms the conviction under 302 and confirms the sentence also to life. So it's a concurrent finding with respect to the conviction also as well as to the sentence also. Now he comes to me. He comes to our office and he says, "Sir, please file special leave petition." So after seeing that there are concurrent findings about the conviction and the sentence, we generally feel that the Honorable Supreme Court will not entertain with respect to the concurrent findings. But there is something very important for younger generations to learn. Whenever we read a judgment, we need to read from the beginning, before the court, in the court of. Reason is, if we start reading from there, otherwise you should not read from the caption of the judgment. After 2 pages, the judgment will start. Then people are start reading from there. That should not happen. You should start from the beginning. In the court of, which judge the matter has come before, and which year, the name of the case, which year it has been filed, and what is the cause title, what is the address. People generally ask, what is the need to read the cause title pending before the trial court or in the trial court judgment? Because by reading the cause title, it has changed the life of Raja Bhaiya. So what was the changing factor? In the cause title it says, Raja Bhaiya Singh, age 17 years, appears to be 21. Age 17 years, appears to be 21. If his age is 17 years, he will fall under juvenile. And how he was tried by the learned trial court, and how he was sentenced to life. So I asked him a very pertinent question. What is your educational qualification? He said, "Sir, I have passed my 10th. And I asked him to bring his 10th certificate, because from which we can find out what is his date of birth. And at the time of commission of the offense in the year 1982, he was only 17 years as per the school record also. So I prepared special leave petition by urging all the grounds, even on the ground of juvenile also. I have made the SSLC mark statement as a part of the record. And it came up before Justice, Honorable Justice Kanvilkar. When I argued the case, my lords, there are case laws which says that ground of juvenility can be taken at any stage. So therefore I have taken it. Lordship said, "Have you taken this plea before the learned trial court or before the high court?" I said, "No, we have not taken it. But your lordships may peruse the learned trial court judgment, wherein it specifically says age 17 years. In support of that, I have produced." Then my lord said, "I am adjourning the matter." This is very important to our topic today. "I am adjourning the matter, move an application to urge fresh plea before the Supreme Court. An application seeking permission to file or to make new grounds. So I am adjourning the matter for 2 weeks." So the matter was adjourned. The plea of juvenility, which we have not taken before any courts. So we took all the fresh plea in the application seeking permission. Then matter came up before Honorable Justice. Then notice was issued to State of UP, and after Standing Council effected appearance on behalf of State of UP, the matter was referred, though it was kept pending, to ascertain the age it was sent to Juvenile Justice Board and submit a report within 3 months. Report was submitted wherein they specifically stated, yes, he was a juvenile at that point of time. That is in the year 1982, when the offence was committed, alleged offence was committed. So then we argued not only on the ground of juvenility, because he was addressed as A2, accused number 2, who was A1, Ram Manohar Singh, his father. So what we stated before the Honorable Supreme Court was, my lords, the allegation against Raja Bhaiya was that he stabbed and caused the death. There were some gunshot injuries on the dead body. But allegation against Raja Bhaiya was that he was carrying knife. And there was no injury out of knife. So therefore we have stated there was no common intention and the injuries were only gunshots. But what he had as per the prosecution was only knife. Therefore he did not commit the offence at all. So matter was argued at length and he was acquitted. Though there were concurrent findings, he was acquitted by the Honorable Supreme Court of India. The point which I want to emphasize here is reading of the judgment in entirety. Assuming that if I had not seen that, if I had started from reading the judgment, I could not have made this point of juvenility. He must have landed in jail because of the fault of the advocate. So therefore, when we pay kind attention to the matters, it changes the life of a person. Otherwise, he has to undergo life sentence. One letter has changed his life. So the Honorable Supreme Court has entertained fresh plea on the ground of juvenility, and it can be taken at any point of time. Why? Reason is, it is a beneficial legislation. Juvenile Justice Act is a beneficial legislation. Therefore, it goes to the root of the matter. And for assuming that the Honorable Supreme Court has said that I will not entertain fresh pleas because you have not taken us before the learned trial court or the high court, what is the consequence? His personal liberty is deprived of. The well-cherished right is, the valuable right is Article 21, right to life and personal liberty. So therefore, dear friends, to advance substantial justice, to meet the ends of justice, to do complete justice, these are the procedures or only the handmaiden of justice. So procedures, technicalities should not come on the way while rendering substantial justice. So that is the message and that is the exception with respect to the new plea with reference to the facts are concerned. Now let me take you to the law is concerned. Can we raise new question of law before the Honorable Supreme Court? See, the general rule is, when it is a question of law, the Honorable Supreme Court entertains such a new plea. But there are exceptions also. At times, they do not interfere, though it may be a substantial question of law. Why? Reason is because of their discretionary power vested under Article 136. They will say, yes, there is a substantial question of law, but still we will not interfere and we will dismiss the matter, but we will keep the question of law opened. In some other cases, we will entertain, but not in this case. So therefore, dear friends, from this, what is reflecting is, it is purely a discretionary power because of the honorable judge's wisdom and their experience will guide them whether to interfere or not to interfere. In such cases, what sort of questions we can raise before the question of law, you can raise before the Honorable Supreme Court with reference to the jurisdictional issue, which goes to the root of the matter. So the trial court or the high court passed the order without jurisdiction that can be entertained by the Honorable Supreme Court. Sometimes the suit was barred by limitation and that was not considered by the learned trial court or the high court, we can urge, even if we are not urged before the learned trial court also or high court also, we can urge before the Honorable Supreme Court that it is barred by limitation, because it is also a question of law. But in certain cases, there are some cases where the Honorable Supreme Court has not entertained SLP, even by raising a question of jurisdiction also, as well as the limitation also, because they felt that it is not a fit case. So we have covered question of fact, question of law, and one more thing is, when the Honorable Supreme Court can take into consideration the subsequent events or change in law. So the Honorable Supreme Court always can consider when there is a change in law or the subsequent events, when it goes to the root of the matter, when it is not taken into consideration, if it causes miscarriage of justice, then they will definitely consider, and then they will look into the subsequent events or change in law. Might be a new plea, but still the Honorable Supreme Court will look into it in order to avoid, in order to prevent miscarriage of justice. So to sum up, dear friends, can we raise new plea before the Honorable Supreme Court? That is the question that we have posed to ourselves. To approach that topic, we have discussed about Article 136 and how it is being interpreted by the Honorable Supreme Court. And on question of fact, generally the Honorable Supreme Court will not interfere. The exceptional cases, Raja Bhaiya, like goes to the personal liberty of a person, they will interfere. With respect to question of law is concerned, generally it is interfered, but in certain cases, because of the Honorable Supreme Court's wisdom and experience, they will say we will not interfere as far as this case is concerned, but we will keep the question of law opened. And third option is subsequent changes in the facts and circumstances as well as in changes in law. Definitely the court will consider by applying its wisdom. So that is the today's lecture on this topic, dear friends. So thank you so much for your patience hearing. I am truly honored to discuss and to elaborate on this topic.